Welcome, and thank you for taking the time to listen to our webinar regarding the Financial Advisory and Intermediary Services Act. The FAIS Act came into effect on 30 September 2004. The aim of the Act is to ensure that financial advice and intermediary services are rendered in a professional manner and to ensure consumer protection. The Act requires all financial service providers to be licensed and, together with its representatives, comply with certain fit and proper requirements and codes of conduct. The FAIS Act provides for the authorization and duties of financial services providers, provisions relating to the representatives of authorized FSPs, issuing codes of conduct, enforcement measures such as the Ombudsman for Financial Services, and exemptions by the Registrar and Minister. Board Notice 194 of 2017 addresses the fit and proper requirements, including honesty, integrity, good standing, competence, continuous professional development, operational ability, and financial soundness. During this webinar, we are briefly going to explain the provisions of the FAIS Act and determination of fit and proper requirement for FSPs as it relates to the governance and risk management of an FSP. An FSP is required to ensure compliance with the FAIS Act and subordinate legislation. The board notice further requires FSPs to adopt, document, and implement an effective governance framework aimed at fair treatment of clients, prudent management, and oversight of the FSP. A governance framework identifies the rights and responsibilities of persons in the FSP, for example, the directors, key individuals, managers, and shareholders, and it generally includes decision-making procedures. The scope of fit and proper requirements of an FSP relating to governance entails identifying the structure of the FSP, establishing and documenting the governance structure, determining the policies surrounding governance, and who is responsible for corporate administration. General governance, therefore, assists an FSP in determining the strategic direction and culture of the organization, the execution of that strategy, managing the risks, and ensuring compliance with the risk management and compliance program. The FSCA needs to authorize FSPs for the rendering of financial services by issuing a license in accordance with the category of the FSP. A person may also not act or offer to act as a representative unless such a person has been appointed as a representative of an authorized FSP. Some FSPs may be subject to the approval of more than one regulatory authority, for example, a bank, a credit provider with the NCR, or a broker under the Medical Schemes Act. Once a license is granted by the FSCA, the FSP will be required to maintain its license. This is done by complying with the provisions of the FAIS Act together with the conditions and restrictions imposed by the authority on how such authority may be exercised. The conditions and restrictions may include the category of financial services and products, the appointment or replacement of key individuals, and their continued compliance with the fit and proper requirements and the updating of business information. These conditions and restrictions may be amended or withdrawn by the authority, and the FSP may also apply for same. Furthermore, an FSP is required to familiarize itself with the reasons and procedures in relation to the lapse, withdrawal, or suspension of a license. The authority may suspend or withdraw a license on certain grounds, in which case they must inform the licensee and give them an opportunity to make submissions. If the matter is urgent and substantial prejudice may occur, the FSCA may provisionally withdraw or suspend a license. Section 19 of FAIS requires an FSP to maintain full and proper accounting records, to update those records monthly, and to prepare financial statements annually. More specifically, Section 19.2 of FAIS requires the financial statements to represent the state of the FSP's affairs and to highlight material matters which has affected or may affect financial affairs. These financial statements have to be audited by an FSCA-approved auditor. Certain exemptions apply to the submission of audited statements. Chapter 6 of the Board Notice sets out the financial soundness requirements applicable to all FSPs and its juristic representatives. The requirements are, however, not applicable to key individuals, natural person representatives, and registered banks or insurers. Financial statements must be submitted to the FSCA by no later than 4 months after the end of its financial year. One can apply for an extension on sufficient grounds at least 15 days before the submission date. Furthermore, if an FSP holds money or assets on behalf of clients, the FSP is required to submit an external auditor's report to the FSCA. Chapter 5 of the Board Notice states the general operational ability requirements that apply to FSPs, key individuals, and representatives. This refers to the ability of an FSP to function effectively and to render the financial services for which it is authorized. A governance framework needs to be implemented by an FSP, which includes a business plan, risk management policies, procedures, and systems. The FSP requires accounting and remuneration policies and procedures, a business continuity policy, recovery and resolution plans, and, lastly, systems that enable monitoring and evaluation. The FSP needs to ensure that they keep record, maintain, and store information and/or records required by the FAIS Act. An FSP must exercise due skill, care, and diligence when entering into, managing, or terminating an outsourced arrangement. Key individuals and representatives also need to comply with the operational ability requirement, and as such, separate operational requirements need to be considered before appointing these persons. The risk management process consists of risk identification, assessment, mitigation, and monitoring. The FAIS Act requires an authorized financial services provider with more than one key individual or one or more representatives to appoint a compliance officer. The function of the compliance officer includes overseeing the FSP's compliance function, monitoring key individuals and representatives' compliance with the Act, and, lastly, submitting irregularity and compliance reports to the authority.